Basic features of the Act: a social security legislation from the central government applicable to employees engaged in factories, shops or other establishments employing 10 or more employees on any day in the preceding 12 months. It covers any person other than an apprentice employed for wages in any kind of work, manual or otherwise. It is a gratuitous gift from the employer made at the end of the period of employment. Key components: continuous service, terminal benefit, maximum limit, and the formula of calculation. The Act stipulates 5 full years of continuous service with the current employer for payment of gratuity. The requirement is not applicable in case of death or disablement due to accident or illness. As held in Mettur Birdsell Limited, Madras versus Regional Labour Commissioner, 5 full years is also equivalent to 4 years and 240 days of continuous service, and in the case of 5 days in a week working system, it is stipulated that mere 4 years and 190 days can be considered as a compliance of requisite continuous service. Continuous service implies service without interruptions. Continuity is assumed to have been not affected where the break is due to reasons beyond one's control, or the break is not voluntary, or the break comprises of any paid leave, temporary disablement, maternity leave, layoff, strike or a lockout. Terminal benefit is payable on any of the 3 situations: on superannuation, that is attainment of age fixed in the contract, or on retirement, resignation or termination of service, or in the event of death or disablement caused by accident or disease. Rupees 20 lakhs is the maximum limit for total gratuity in one's lifetime, and this is once again subject to the prescribed gratuity formula. However, it is open to an employer to contract to pay more than the amount of maximum limit, but anything outside the gratuity formula will be taxable in the hands of the employee. Gratuity is calculated for the entire period starting from the date of joining till the last working day. Gratuity equals last drawn monthly salary into 15/26 into number of years service. Last drawn salary includes basic salary plus dearness allowance. 15/26 represents 15 days out of 26 working days in a month, and service less than 1 year, if it is 6 months and in excess of 6 months, is rounded off as 1 year. The 3 unique concepts of nomination, death of an employee and forfeiture. An employee is required to make a nomination within 30 days of completion of 1 year of service. Nomination shall be made in favor of 1 or more members of family. Family includes spouse, children, dependent parents, widow and children of predeceased son. In the absence of family, nomination can be made in favor of any person. However, whenever a person acquires a family, it is mandatory to make a fresh nomination within 90 days. Gratuity payable on the death of an employee shall be paid to the nominee. If no nomination has been made, payment shall be made to the legal heirs. A legal heir can apply within 1 year from the day the gratuity is payable. If the nominee or legal heir are minor, the gratuity is deposited by the employer with the controlling authority until such minor attains majority. Forfeiture is permitted after due process of law of show cause, hearing and termination. To the extent of loss, forfeiture is permitted for any act, omission or negligence causing damage, loss or destruction of property. Wholly or partially, forfeiture is permitted for riotous or disorderly conduct or any other act of violence on the part of the employee. Similarly, forfeiture is permitted for any act which constitutes an offence involving moral turpitude, but the only condition is it has to be in the course of employment and only after court conviction is obtained under law. Gratuity process involving application, value determination, payment, delayed payment and interest, disputes and redressal. A person entitled to gratuity shall make an application to the employer, and the application shall be made within 30 days ahead of the date it becomes payable, and the employer shall determine the amount of gratuity and give notice specifying the amount to whom payable, and he will intimate the controlling authority to that effect. The employer is obliged to pay the amount of gratuity within 30 days from the date it becomes payable to the eligible employee or his nominee or legal heir by check, draft or through net banking, and he shall report the details to the controlling authority simultaneously. If there is a delay in the payment of gratuity, interest at the rate of 10% per annum is payable for the duration, except when the delay is due to the employee or the delay has been permitted by the controlling authority. The employer shall deposit with the controlling authority the amount as he admits to be payable whenever there is a dispute as to the amount of gratuity or on the admissibility of any claim, or in relation to an employee or as to the person entitled to receive the gratuity there is an issue. The controlling authority shall hear and review the case in order to ensure that the dispute is settled and the deposit is rightly paid to the applicant or nominee as applicable. Controlling authority appointment, powers, passing of order and recovery of dues. Controlling authority is appointed by the appropriate government and he will be responsible for administration of the act in the specified location. Employer, employee, nominee or any other aggrieved may apply to controlling authority within 90 days for disputes involving refusal to accept nomination, refusal to accept gratuity application, or where the employer indicates lesser amount as eligible gratuity and similar matters. The controlling authority has court powers on getting attendance, documents, evidence and issuing commission. It can pass orders after hearing with reasons and direct employer to pay such amount, and anyone aggrieved from the order of controlling authority may appeal within 60 days to the appropriate government, but the requirement is that can be done only after depositing the amount of gratuity payable as per the order of controlling authority. Gratuity, if not paid as per order, is recoverable as an arrear of land revenue with interest at the rate of 9% per annum. Payment of Gratuity Act. Basic concept, key components, concepts of nomination and forfeiture, gratuity process, controlling authority and 4 labor codes. The central government has passed 4 bills on labor codes between 2019 and 2020. The 4 labor codes are Code on Wages, Industrial Relations Code, Social Security Code and Occupational Safety, Health and Working Conditions Code. The 4 labor codes are set to consolidate and replace 29 labor laws as existing now. The rules for all the 4 codes are awaited for early finalization and implementation. Progress review of Gratuity Act. Gratuity is paid as a consideration for past services rendered by an employee and it is paid as a lump sum. Payment of Gratuity Act applies to every shop and establishment which employs 10 or more employees. Gratuity is normally the last payment. It is paid on the termination of employment of a person. It is always payable to an employee. And the last part of the service may be marked by any one of these 3. It may be a superannuation when a person reaches a particular age, or when he retires at the end of his service, or he is retrenched based on the terms of order, and it is payable to an employee in any of these 3 situations. An employer may be exempt from having payment to gratuity when he establishes his own approved gratuity fund, and this is permitted under section 4A in respect of employers who are employing 500 or more persons and who have got a scheme which matches or improvises over what is prescribed by the government. And in case of gratuity, there is one requirement that a person should have worked for a minimum of 5 years continuously with the employer. In case of continuous service calculation, maternity leave granted is taken as a part of mandatory service. Gratuity calculated for every completed year of service and any part of the years of service in excess of 6 months at the rate of 15 days of last drawn salary. Salary means basic salary plus dearness allowance. And the maximum amount of gratuity that can be paid to a person is frozen at rupees 20 lakhs, and it is 20 lakhs or 20 months salary, whichever is less, and the gratuity has to be paid within 30 days from the date it becomes payable to the eligible person. If there is a delay in making payment of gratuity beyond 30 days after it is due, the employer is liable to pay interest at the rate of 10% per annum. While calculating the gratuity, average days are taken to be 26 days for working in a month. Every employee has to give a nomination for the proceeds of gratuity as and when it becomes payable in his absence, and that nomination has to be given once he completes an year of service. When an employee who hitherto didn't have a family, if he acquires a family, within 90 days of such acquiring a family, he has to file a fresh nomination. If an employee, if he already has a family and he files a nomination, the nomination has to be in favor of a person who is a member of his family. If he files a nomination in favor of a person who is not a member of a family, such a nomination is void. And for the sake of family, father-in-law of a female employee is a part of the definition of family. If there is a dispute on the amount of gratuity payable, the employer can pursue the dispute, but before that, it is safer for him to deposit the gratuity with the controlling authority and proceed with the dispute. And the controlling authority may give his decision, and any decision given by him can be appealed, but the appeal has to be filed within 60 days from the receipt of order of the controlling authority. Now, there is a limit of 60 days for filing of appeal, but if sufficient cause is shown, the government may condone the delay and it may give time up to another 60 days. And an employer has got an obligation to display in Form number U an abstract of the Act and rules of gratuity in the premises. No gratuity which is accumulated in the name of a person can be attached against any decree of court. An employer also cannot contract it out. The employer cannot make agreement with the employee to pay gratuity below the amount fixed by the Act. As regards service of notice, a notice may be served by the employer to the employee or employee to the employer in respect of payment of gratuity. Any such service of notice or communication, it can be by personal service after taking receipt, or it can be by registered post acknowledgement due. The Payment of Gratuities Act does not mention anything about service by courier. An employer who is already under the Payment of Gratuities Act coverage, employing the specified number of people, if he intends to close the business, he has to give a notice 60 days in advance of intended closure, and the notice has to be sent to controlling authority.